Good afternoon. Thank you for joining us for part 3 of the webinar series on Real Estate Academy Property Management course. This is Victoria Beal with the LTAP Center, and I have with me my colleagues from the real estate section, Tyler Prose and Scott Recker, and they are going to be presenting the course material today. I'm going to close out the survey that we had running and share the results with you. We have 69% ODOT employees on today, 31% government, other state or local, and then 3% other. So welcome. We're glad to have you with us. And I wanted to mention that we do have a question box. And if you haven't done so already, if you could please find it, just drop me a hi or hello so I know you found it. That's how we'll be accepting questions throughout the webinar today. And last but not least, in the handout section, we do have a copy of today's slides. So you can download them from there, or we will also email them out after the webinar today. So Tyler, that's all I have. Are you ready?
Yeah. Could you actually, the thing you emailed today, could you put that in the handouts as well?
The answers?
Case study answers? Yeah.
Absolutely. I will drop that in there too. So
make it easier for everyone.
I think I might need you to reshare, stop sharing and then reshare your screen. Looks like my poll results are stuck. I'm sorry.
Wait,
So if you go under sharing, you'll see a button to stop sharing your screen. And then
wait, it says stop showing screen?
Yep, hit
That's
that.
X'd out. It's dark. I can't.
You can't? Okay. How about show? Is that available?
Nope.
Hmm.
Those two are dark to block, or they're grayed out for me.
You know what? I'm going to switch it to myself as presenter real quick, and then I'll switch it back to you, and then that should hopefully fix it.
Perfect.
More than one way to approach this. Okay, let's have you share your screen.
It's still blacked out for me.
Well, I wonder why it's doing that. I apologize. I wouldn't have ran the poll if I'd known it was going to give us this type of heartache. All right, Scott, I'm going to move it to you real quick. If you could please accept and show your screen. If you're talking to us, you're muted.
All right.
Hang on, everybody. We'll have it figured out here in a second.
While you're figuring that out, do you want me to walk, or do you want me to talk about the case study?
Yeah, that'd be great.
Hey, Victoria.
Yes.
I got a thing that says sharing poll results. Organizer must hide poll results to enable screen sharing.
You know, the poll result thing is it disappeared off my screen, so I'm going to put it back to me and see if I can switch it to maybe share my screen instead. And Tyler, why don't you go ahead and, oh, Tyler looks like he disappeared. So we're going to have to wait for him to come back. Here he is. He's getting right back on. You know, you have those days. Tyler, are you here now with us? Okay. I think, well, you go ahead and talk to people. I think I'm going to go out and I'll come back in.
Okay.
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 So,
welcome back, guys. Thank you for coming to the third day, the third module. We're going to start by going over the case study 2.1, excess land sale and multiple abutters. Today, yesterday, she sent out the actual case study. Today, before the class, she sent out the case study with the answer. With this, there's the colored or the grayed out parcel is the parcel we're in question, and there are 4 abutting owners. They're in red if you see my screen. If not, they're the 4 on the outside, and then there's a road. The case or the facts are that this property has been all through all in-house reviews, including environmental. ODOT or ODNR does not want it. Federal Highways says it's approved, and no local agencies want it. You have a property at appraised for $16,000, $2,000 for an appraisal, $1,500 for an advertisement to run an auction. Okay, what are the 2 ways that you could, or what are the ways you could sell this property? I just slipped up. But what are the ways you could sell this property? Since we don't have since we don't have the chat feature, the district could either sell the property at a public auction, or they could sell it to the 4 abutting owners. If you go through a public auction, you need to prepare the notice of sale. In this case, since it is an auction, you need to include the appraisal and the advertising plus FMVE as your list price. So that is $16,000 for the parcel, $2,000 for the appraisal, and $1,500 for the advertising. Step B, make arrangement with an auctioneer, either in-house or consultant. C, discuss with the DDD and seek written approval for any amount less than full market value, up to 2/3. Prepare a sales brochure marketing flyer. Run the ad in a local newspaper for 2 consecutive weeks prior to the auction, and the first date shall be at least 21 days prior to the auction. Mail a notice of sale to all abutting owners. Send marketing flyer to local real estate brokers. Put an auction sign up at site. On auction day, arrive early to open property and answer questions. To start the auction, you need to read this notice of sale. Auctioneer calls the auction. Successful bidder provides their deposit and signs both contract and non-collusion affidavit. Then the contract is signed by an ODOT official. You send a fully executed copy to the buyer. Prepare the chronology of events and send a request to Auditor of State for a governor's deed. The second way you can handle this sale. Here's a colored version of what I was talking about on the screen now. This is what I just went over, and then this is the direct sale to abutting owners. First step, prepare a notice of sale by sealed bid. You'd list the price at $16,000 or $18,000 if you want to include the appraisal or not. Our opinion in property management is that you should probably include the appraisal and get as much money back as you can for this property. So we would go with probably 18,000. But since you're not advertising, you do not need to add that $1,500 in that you would spend. Then you need to mail the notice of sale with bidder's instruction to all abutting owners. Notify the mailroom to not open the bids and to keep them secure. On the date and time of bid opening, all sealed bid forms are opened and the district creates a memo on the bids tabulated. All unsuccessful bidders have their security deposits returned, although you will keep a copy in your files. If the bidders are present, you return it immediately. If they are not, then you return it within 3 business days. Successful bidders deposit as cash and they sign both the contract of purchase and the non-collusion affidavit. Contract countersigned by ODOT. Send the fully executed copy to buyer. Prepare chronology of events and send a request to Auditor of State for governor's deed. When in the first question, would it ask what would be the options? I hope you didn't say absolute auction because it is not less than $5,000. And if you would get it reappraised at under $5,000, then you could do a absolute auction. With that, I am going to pass it over to Scott.
Sounds good. I'm making Scott the presenter now. And sorry for the technical issues, guys. We got it figured out though.
Thank you, Victoria.
There is a quick question that came into the question box. Why don't I read that off to you real quick, Tyler? And I'll send it to you too. It says, in the second option for direct sale to the abutters in sealed bid, if they request, are they able to see the appraisal?
Yes. We don't hide the appraisal. It's not a, it's not a confidential document. So we always would, or we will share an appraisal.
That was the only question we had.
And if you're at the auction, it's good to bring the appraiser if they're available to say, oh, this is why I appraised it like this, or
Sounds good. Okay, Scott, we can see your screen. You'll need to unmute.
Okay.
Thanks.
Good afternoon, everyone. We're going to go over today, it's governmental land transfers. And these are fairly common activities that we do here and are routinely processed at the districts. Our learning outcomes for this module will be hopefully at the end of the module, you'll be able to understand when ODOT may transfer property to another governmental agency and know how to process a transfer through the district and central office. You'll also be able to explain when the reversionary interests must be maintained and also understand how ODOT transfers roads and roadside parks. The transfer to a government agency at less than fair market value. So here's the law that explains that how we can transfer or how we're allowed to transfer to another governmental agency at less than fair market value. It's revised code 5501.45 paragraph E section 1 allows a director to transfer real estate by director's deed to state institutions, agencies, commissions, instrumentalities, political subdivisions, taxing districts, institutions receiving financial assistance from the state or the federal government upon such consideration as shall be determined by the director to be fair and reasonable without competitive bidding. Paragraph 2 defines an institution receiving financial assistance from the state to include any public or private organization, especially one of charitable, civic, or educational character, in receipt of a state loan, grant, or other type of state financial assistance. You'll see at the bottom of this slide, it shows several companies that would qualify for that. And this doesn't have to just involve selling real estate to institutions. As many of you probably know, ODOT has worked for years with Habitat for Humanity in providing our structures that are set for demolition to them. They go in before we demo a property, remove any salvageable building materials, and which they then sell in their restores. If anyone has any questions or would like to do that, has any demolitions of structures coming up and would like to do that, please feel free to contact central office, Tyler, and he will walk you through the process needed to take advantage of that. In addition to all the customary property disposal approvals that we went over in detail in Module 1, ODOT Director approval is required for any disposal of property to another governmental agency for less than fair market value. If you look at your excess land flow chart that we had earlier, you'll see that there's a fork in the road which comes to the approvals for direct sales to LPAs or local public agencies. If the plan is to transfer at less than fair market value, then the district deputy director shall forward any request to the Office of Real Estate. All requests will be responded to in writing by the director or the director's designee. All requests must include the information regarding the proposed buyer of the property, and if they qualify as an institution receiving financial assistance from the state, the district should provide any relevant support documentation. It should also include a statement about the proposed continued public use for the facility, a copy of any appraisals or estimates of value that may have been prepared for the property to be sold, and any environmental reports that would affect the disposal and or the proposed sale. All requests must include also a statement about the reversionary interest to be retained in the name of ODOT. As stated in 23 CFR Part 710.409D, where the transfer of excess property to other agencies at less than fair market value for continued public use is clearly justified as in the public interest and approved by FHWA, the deed shall provide for reversion of the property for failure to continue public ownership and use. So that in that case, a local agency or say a local city or village couldn't get property from ODOT at less than fair market value and turn around and sell it to a private individual at fair market value and make a profit. When there's federal funds used in the original acquisition, any sale at less than fair market value must be approved by FHWA also. All statements must include the following information: a statement regarding the perceived benefits to the department for making the sale at less than FMVE. Support documentation must clearly show public benefits and how the state will receive the same. And information regarding the original funding for the property to be disposed, including details on federal funds involved in the original acquisition and or construction. Transfers under 5501.45 of the revised code are only to be used in situations where a qualifying entity will continue to use the property for public purposes. If the intent is to subsequently sell or otherwise convey all or portion of the property, then a transfer for less than FM fair market value is not appropriate. Instead, those conveyances should be conducted at full fair market value. As we have covered briefly in Module 1, you will finalize all land transfer conveyances via a director's deed. A director's deed is different from the governor's deed we use on all sales to the public. First, it is drafted in the district. It is signed by the director or their designee. It is much, much faster to obtain than a governor's deed. And we'll review our standard director's deed in a moment. You can have one in the handouts, or there's copies of director's deeds on the website. There is also a different contract of purchase for these transactions. As you see on your slide, we use RE 74-05G, contract of purchase for a government transfer. We will review it now. On the first page, you'll see that the contract looks very similar to our standard contract that we use on all public sales. At the top, and again down in the third paragraph, we cite Revised Code Section 5501.45E. In the third paragraph, we also state that the grantee qualifies as an entity under the law, which means you must first obtain necessary proof that they do. So you want to make sure that the entity does qualify for it, because it does state it right in the contract. On the second page, we have a lot of important conditions. First thing highlighted shows the conveyance will be concluded using a director's deed, which quitclaims our interest except for any mineral rights. Just to remember, ODOT does not warrant or defend title on any property it disposes. Moving down the page, you will see that the contract calls for continued public use, which should be a tip that the director's deed will contain a reversionary clause. Next, you see that we have several non-discrimination terms and conditions. These non-discrimination terms and conditions are born out of federal law and must be in all of our deeds and contracts where we are not selling property to the public. Highlighted on the third page, where it states if any of the above non-discrimination clauses is violated, the property will immediately revert to ODOT. On the fourth page, you'll see that we are that we are transferring the property as is, where is, with all faults, and that ODOT will fully disclose what it knows, but the grantee is accepting it as is. This includes all environmental liability and responsibility. Make sure your grantee understands what they are signing and agreeing to. You may also remember seeing a very similar statement on all our excess land marketing flyers like the ones we reviewed in Module 2. On the last page, you will see that the contract can only be signed by the director or his designee. If you do not have signature authority for the director, do not sign the contract. As we have just reviewed, there are a lot of terms and conditions in this 5-page contract. Terms and conditions that are not fully repeated in our director's deed. Thus, it is critical and important that you use the RE 74-05G in conjunction with your director's deed. The two documents reference each other and go hand in hand. Make sure you always have the two documents fully executed in each transfer. Now let's review the director's deed with mineral reservations. On the first page, highlighted is a few important clauses. First, the deed states that the director of ODNR was consulted and determined they did not need the property. Next, you will see where you verified and determined that the grantee qualifies as an eligible entity under the law. And finally, on this page, you will see where the deed references the contract we just reviewed. On the second page, you'll see where the contract is again specifically mentioned, and further that the grant is a quick claim. Next, you'll see where we are reserving all mineral rights. But if you read the last sentence of that clause, we will not have any right to access the surface. We only reserve the subsurface mineral rights. You'll also see that the transfer is subject to continued public purposes, and that if the grantee fails to maintain it as such, the property comes back to ODOT immediately. Also on this page, you see where the non-discrimination clauses begin. On the third page, you will see the remaining non-discrimination clauses and the language that the property will revert to ODOT if any are breached. The director's deed also states that the non-discrimination clauses are covenants that will run with the land. Regardless of what the grantee does with the property, the non-discrimination clauses are there for good. And finally, you will see the deed is signed by whom? The director or his designee. The last page is simply a notary block, but it's good to note that the deed requires a notary, whereas the contract does not. And just as some advice, if you are not already a notary, it's highly recommended that you get yours so that you can properly notarize these documents while you're doing these transactions, and your agency will more than likely pay your fees. Next, we're briefly going to go over a couple other transfers that happen periodically. One is transfers of roads. Upon completion of construction of a road to be transferred to a county or say another local government authority, the district deputy director has a location plan prepared showing the location of the road as built and the limits of the right-of-way acquired. The district will then arrange inspection of the work by the county commissioners and the county engineer or comparable legislative and administrative authority, if other than county, and secure from them a formal acceptance of the new road. A director's deed must contain a reversionary interest clause. After recording, the district will maintain a copy of the recorded instrument and update necessary right-of-way plans to show the conveyance. Next are transfers of roadside parks. Once the determination is made to cease operating a park, the district's office will either transfer the park to another agency or close the park and dispose of the property interests. The district must investigate whether the instrument, typically an easement, through which the department acquired the property, gives us authority to transfer the property to another governmental agency. The district may need to seek advice and guidance from the Attorney General or ODOT's Chief Legal Counsel as to what their rights may be. Roadside parks transferred to other political jurisdictions for maintenance and public use must be maintained and used for public purposes. Otherwise, they revert to the grantor, which would be the state of Ohio. A statement to this effect must appear in the chronology of events as well as the director's deed. In this photo, you'll see old Annie Oakley Roadside Park. This picture was taken in 2017. The park was established in 1953 when the York family donated approximately 1 acre to ODOT in Darke County, adjacent to US Route 127. The on-site well was sealed in 1999. In the ensuing years, ODOT removed the restrooms and most other accommodations, leaving only some picnic tables and grills. The York family felt the property was no longer operating as a roadside park and requested that the land revert to them as provided for in the original donation. ODOT then removed all remaining improvements and transferred the approximately 1 acre parcel back to the York family as provided for in the reversionary clause. Okay, I think today we are not going to go through reviewing the learning outcomes that I just went over. You guys can go through those on your own. We're going to try to tackle part of Module 4 so that tomorrow we can do the other half of Module 4 and all of Module 5 to finish this training up. So I will turn, if there's no questions or anything, again, type them in the box, but I will turn it back over to Tyler and he will begin with Module 4.
There's no questions at this time, so I'm going to move it right back over to Tyler.
Perfect, thank you.
Thanks. Tyler, I think you muted yourself. You're going to need to unmute so everyone can hear you.
Is that better? Sorry.
Yep, we can hear you now.
Okay, thank you. We're going to go over abandonments and vacations for the rest of this class. Pursuant to RC 5511.01, the Director of Transportation may abandon a state highway or segment thereof. Upon abandonment, the highway becomes a county or township road or city street. The road remains open to the public travel, and abutting owners have the same rights of access as they had before abandonment. Thus, there are no concerns about damages, and the law makes no provisions about paying damages to abutting owners. Even though there is no record transfer of title, all maintenance, repairs, and operations of the roadway becomes the responsibility of the local public agency. The Central Office Division of Planning, Office of Technical Services, sets policy and procedure and maintains a statewide record on abandonments. These are really rare. We don't do them very much at all. But if you have an abandonment, you need to contact Dave Gardner at the Technical Service Office and Central Office.
Tyler, you muted yourself again.
Huh?
Okay, you're back. Nope, you're still muted. Your microphone looks like it's unmuted on my end, but I don't hear anything.
Can you hear me now?
Yep.
Sorry, it keeps muting it for some reason. That's okay. Highway vacations. Pursuant to RC 5511.07, the director may vacate a highway or portion of a highway on the state highway system if it is no longer needed for highway purposes. Vacation procedures apply whenever the disposal of current or former right-of-way would negatively affect the ability of an abutting owner to use or access a highway. The law recognizes that damages may occur. Vacated portions of the state highway, whether owned by the department in fee or easement, shall be disposed of to the underlying fee owner or abutting property owner at no cost. Vacation of highway is accomplished via recording form RE 74-42, Highway Vacation Instrument. Again, you can find this on our website. Vacation of a highway is typically used when an entire highway or portion is being removed from the state highway system, and neither the state nor any local governmental agencies will continue its use as a public roadway. Vacation of a highway is not a common occurrence, and the district should thoroughly examine the decision to remove a highway or portion thereof from the state highway system. Vacation is also appropriate when the disposal of a remnant right-of-way will negatively affect the ability of an abutting owner to use or access the highway. Before disposing of any remnant right-of-way, whether it's held in fee or by easement, the district must determine whether the disposal of the remnant right-of-way will negatively affect an abutting owner. If the district determines that disposal will negatively affect an abutting owner, the district must follow the vacation process. If the district determines that the disposal will not negatively affect any abutting owners, the district may proceed with disposal. If the property is held in fee, the district may dispose of the property as excess land. If the property is held by easement, the district shall extinguish the easement to the underlying fee owner. Notice to abutting owners. A notice of vacation of right-of-way form RE 74-11 is prepared by the district and mailed to all abutting owners by certified mail, return receipt requested. It is also published once a week for 2 consecutive weeks in a newspaper of general circulation in the county where the property is located. Owners whose place of residence is unknown or are non-residents of the state are specifically named in the notice of publication. In every vacation action, the notice must be mailed by certified mail to the Director of Natural Resources to comply with the ORC. The notice fixes a vacation date not less than 20 days after the date of the final publication and sets forth the procedure for filing claims for compensation or damages. Here's an example of an actual notice of vacation that was created for a project in District 10. Let's review the main components. Here you'll see the general announcement that the highway is to be vacated. Next, you will see the description of the area to be vacated, along with an overview of procedures to be followed. And here we state that all abutting owners should take due notice and file any claims for damages. And failure to file a claim as set forth in the notice constitutes a waiver of damages. And remember, you must mail a copy of this to all abutting owners. We cannot assume they will see it in the paper. And make sure you send it registered mail, return receipt requested, so you have evidence of it being delivered. The district receives all claims and enters the hour and day received. If no claims are filed within the time period contained in the notice, the district office will complete the vacation proceedings. When claims are filed, district examines and orders appraisals for each. Appraisals are reviewed, and if award is justified, FMVE will be established following standard appraisal procedures. Once FMVE is established, an offer will be made following established acquisition procedures. If damages are great, affected owners may be entitled to relocation benefits. Appraisal. Appraisal of highway vacation damages follows the format of standard before and after appraisal and appraisal review used to determine just compensation in acquiring right of way. See the 4000 series of the Real Estate Policies and Procedures Manual for all appraisal requirements. There were both lands to be acquired and lands to be vacated are included in the same appraisal. Separate amounts must be clearly stated. This is rare, but may happen on a project. Claim review and negotiations. District will examine the amount of any claims, the review appraiser's findings, and all matters pertaining to cost. If it finds all costs are within the range of agency's estimates, it will proceed with vacation action negotiations. When agreement can be reached, a settlement and release of claims form RE63, negotiation summary report form RE60, and the negotiator notes form RE60-1 are completed. Payment is processed the same as all other right-of-way payments. You fill out the form 24-1. When agreement cannot be reached, the forms RE60, RE60-1, and RE60-1, appropriation attachment to negotiation notes, are processed and completed the same way as the appropriation of the highway rights of way. Finalizing the vacation. Upon satisfaction of all damage claims, either through negotiations or court actions, the districts will prepare and execute a highway vacation instrument, form RE 74-42, for each parcel being vacated. The instrument shall be distributed to all affected property owners to the county recorder. The district shall retain a certified copy of the recorded instrument in the disposal file. If the district shall indicate and note the vacated area on the permanent right-of-way plan and send a copy to Central Office Property Management. You can send that to me. Okay. So here we have examples of documentations used in highway vacation. First is the plan sheet that shows the section of the roadway to be vacated. Note the parcel 85 VAC crosshatched in the middle of the section. Next is the settlement release of claims form RE63. This is a form the owners sign releasing ODOT from any claims when the roadway is vacated. This is signed after successful negotiations on any damage claim payments to the owners. And here you will note there was no payment, so they don't always end up with a damage claim payment. Not all roadway vacations end up in people moving. On Athens 124, the owners banded together and gave each other non-exclusive access and kept the road open as a private gravel road. In Athens on 124, they were having problems with a bunch of slippage, or they're having slips every year. So that district decided that it was unfeasible to keep maintaining that road. So they vacated it, and all the owners banded together and gave a non-exclusive easement across all of it, or across the road, so each one of them could get to their properties. A lot of those properties were secondary homes or vacation homes in the country. This is the actual RE 7442, the form in the form of a director's deed that ODOT uses to convey title to the vacated roadway to the underlying or abutting owners. On the first page, you will note that it has been recorded. And as I just stated, the settlement and release of claims form RE63 will be attached to this deed and recorded as part of the entire package. You will also note that the director's deed states that any utilities currently occupying in the right-of-way to be vacated have a continued right of occupancy. Utilities are always protected in their easements by ODOT. So even if we sell the property, they will always have the right to be on their easement, even if we purchase the easement in our name for them. As you can see in the granting clause, ODOT is quit claiming its interest, fee or easement to the owners. ODOT never warrants or defends title. On the second page, you will see the director's signature must be notarized. And on the next two pages, you will see our legal description of the roadway to be vacated. Okay, now we're going over our review, or we're going to review our learning outcomes. First, we wanted you to understand when ODOT may transfer property, and we went over the governing laws, section 5501.45, which states the director may transfer real estate by director's deed to state institutions, agencies, commissions, instrumentalities, political subdivisions, taxing districts, institutions receiving financial assistance from the state or the federal government. The law defines an institution receiving financial assistance from the state to include any public or private organization, especially one of a charitable, civic, or educational character, in receipt of a state loan, grant, or other type of state financial assistance. You must get proof that they have received state funding in their history. And further, transfers will be at such consideration as determined by the director to be fair and reasonable without competitive bidding. We also wanted you to know about the process of transfer through the district and central office. First off, you will route the transfer through the in-house reviews and make sure that the property is not needed by ODOT and can be transferred to another governmental agency. We covered those in Module 1. You will need to route all transferred by ODNR to make sure they don't need it for recreational purposes. In addition to all normal reviews, any transfer at less than full FMVE must be written in a written approval by the director or their designee. Currently, Drew Gilmore is the director's designee. We discussed that district must make a formal request to Drew for approval and include a whole lot of information about who is to receive the property and their continued public use of the property. District cannot proceed without written approval from Drew. Where federal funds were used in the original acquisition, any sale at less than FMVE must be approved by FHWA. As we discussed in the stewardship agreement, the stewardship agreement does not allow us to approve any disposals or transfers less than full FMVE. When you submit to FHWA, include the same information you submit for director's approval on transfers. FHWA will review and respond in writing. If you're sending anything to FHWA, you need to route it through central office right now because they just had a turnover and they have someone new in there. So if you're sending something to FHWA for approval, route it through central office and we'll make sure it gets the right person. As we discussed, that all transfers require the use of RE 7405G, contract of purchase for a governmental transfer. We reviewed the contract and went over several terms and conditions that are not included in standard disposal contract. Many terms and conditions in the contract are not included in the director's deed, although they are included by reference. We discussed how the contract goes hand in hand with use to convey the property, and you must use the contract on any transfers. We then reviewed the director's deed and how it is different from the governor's deed that we use on all other excess land to the public. First, it is drafted in the district and thus goes faster to, it is faster to obtain. It references the RE 74-05G contract of purchase for a governmental transfer multiple times. It contains reversionary and non-discrimination language. It is also signed by the director or their designee. As far as learning outcomes for the review or for abandonments and vacations, you need to, or we talked about when an abandonment is the right thing to do and when a vacation is the proper instrument. If there are damages, what needs to happen? If not, if there are no damages, how to proceed. We talked about how to create the vacation notices and how they must be advertised for 2 consecutive weeks, no less than 20 days before the dates set forth in the notice. How to process abutting owners' claims, how to keep track of them, and how to get that process started with the appraisal. And how to finalize vacations and write highway vacation instruments. So now we're going to start on our quiz. Number 1, RC 5501.45E Part 1 allows the director to transfer real estate by director's deed to the state institutions, agencies, commissions, instrumentalities, political subdivisions, taxing districts, institutions receiving financial assistance from the state or the federal government. Upon such considerations shall be determined by the director to be.
And this is where we want them to enter the answer into the question box.
Yes,
a bunch of folks are answering already and they put in the letter C.
Man, you are good. The director wants fair and reasonable without competitive bidding. Don't give up. The director is not going to give up something that is worth a lot of value for nothing. They want to get something back. That is our responsibility to the taxpayers of Ohio. Number 2, true or false, RC 5501.45E Part 2 defines an institution receiving financial assistance from the state to include any public or private organization, especially one of a charitable, civic, educational character, in receipt of a state loan, grant, or other type of financial assistance.
There's just a whole slew of T's coming in for true.
You guys are good. Yes. If they have received financial, or if they've received money from the state in any capacity, they usually are part of this, or they're, yeah. And they are open for property at less than fair market value with a reversionary clause. Number 3, in addition to all usual property disposal approvals, all disposals to an LPA for less than FMVE may require.
Okay, let's see who's on it this time. I got one in there. They said D. Somebody else said E. We got D, E. It's kind of evenly split right now between the two. Oh, nope. Then D and E, they split it again. Okay, now the D's are outpacing the E's. So.
Well, thank you for trusting in me in central office property management section, but you do not need my approval. You only need ODOT Director approval or their designee or the Federal Highway Administration approval. Number 4, true or false, 23 CFR Part 710.409D states, where the transfer of excess property to another agency at less than fair market value for continued public use is clearly justified, as in the public interest and approved by FHWA under 710.403 Part E, the deed need not provide for reversion of the property for the failure to continue public ownership and use.
They've been putting in F. Oh, there was one true, but everybody else said false.
Man, you guys are good. False. If it is at less than fair market value, you always have to have a reversionary clause. That there is no way around. That's one of the biggest things that we get calls about in central office is the reversionary clause. When do we need to have it? And if you are ever giving it to a public agency at less than fair market value, they have or there will be a reversionary clause. If a public agency pays for it and they pay full market value, the reversionary clause goes away. It is theirs free and clear. They can do whatever. They can develop it, they can sell it, they can do whatever they need. But if they pay less, there is reversionary clause. They can't enrich themselves off of ODOT is the way it is said. Number 5, fill in the blanks. If it is the intent of the acquiring entity to subsequently sell or otherwise convey all or a portion of the property, then a transfer for blank is not appropriate. Instead, those conveyances should be conducted at, I know this one's a little longer.
To type in. Someone said less than fair market value and then fair market value.
Man, that's good. So I'll just read it again with the fill-ins. If it is the intent of acquiring an entity to subsequently sell or otherwise convey all or a portion of the property, then a transfer for less than fair market value is not appropriate. Instead, these conveyances should be conducted at full market value. Again, these entities cannot enrich themselves from ODOT. Number 6, all transfers to other governmental entities will be conveyed via.
Okay, I'm getting D's in. More D's.
A lot of D's.
That's it. The only answer they've given is D.
Well, it is D, double D, director's deed. Yes, when we're transferring, it is a director's deed. Again, this is a lot easier for us to get. It's a lot quicker. If we're getting a governor's deed, it's going to take us at least 3 months, 2, 3, maybe 4 months if it's depending on how or who's there. But for all transfers, we go with director's deeds. And the last question for the day, true or false? Once the determination is made to cease operating a roadside park, the district office will either transfer the park to another agency or close the park and dispose of the property's interests. The district must investigate whether the instrument, typically easement, through which the department acquires the property provides authority to transfer the property to another governmental agency.
Oh, we have a ton of trues and a false. Another false. Another false.
The answer is true. You always need to go back and see what restrictions are on the deed, the instrument that we got the property with. You have to see what restrictions, if it isn't, just like we have reversionary clauses on ours, some of the stuff we acquire has reversionary clauses. So you just have to be extra diligent, just like the park case that Scott brought up. And with that, that is all we have today.
Well,
thank you for
both.
listening.
Yep. Thanks, Tyler. Thanks, Scott, for your time today. And thank you all for attending. We'll see you on part 4 tomorrow. We'll wrap things up for the week. So take care and we'll see you then.
Thank you.
Thank you.